question is that the bill be now read a second time. Mr. Christopher de Souza.
Mr. Deputy Speaker, sir, I support this bill. First established in 1985, the Small Claims Tribunal provides a quick and inexpensive forum for the resolution of small claims between consumers and suppliers. This forum has been utilized quite heavily. Starting out with a caseload of about 3,000, the Small Claims Tribunal disposed of approximately 39,000 cases in 1999 and 1998. In the most recent statistics available, the numbers were 10,908 in 2015, 10,266 in 2016, and a projected 9,700 in 2017. This bill further enhances the Small Claims Tribunal's bid to promote access to justice in a few ways. Sir, allow me to expand on some important features of this bill, but before I do so, please allow me to declare my interest as a practicing lawyer. Firstly, this bill expands the scope of the Small Claims Tribunal's jurisdiction. The threshold in terms of quantum of claim has been raised. This is a welcome update of the threshold, and it's not the first time the jurisdiction threshold has been amended. In 1984, the threshold was $2,000, with the rationale that resolving such claims through the normal civil courts may be seen to be costly. It was raised in 1995 to $5,000, and then $10,000 with consent, and subsequently to $10,000 and $20,000 with consent in 1997. There have also been important clarifications made to ensure that the monetary limit is applied meaningfully. Under Clause 13, the aggregate value of the claims of persons represented in a representative claim must not exceed the monetary limit. While this will not restrict others from bringing their claims through the Small Claims Tribunal by not aggregating their claim under that representative, it makes sure that a defendant will not face a high-stake claim that exceeds the monetary limit. A similar restriction is applied to claims being heard together by order of the tribunal under Section 26 of the current Act, because of a common question of fact or law, or because the claims arose out of the same cause of action, or because of the interests of justice. Another expansion of the jurisdiction is through the inclusion of some hire purchase agreements, that is, those that fall under the scope of the Consumer Protection Fair Trading Act. Previously, cases related to cancellation of timeshare and timeshare-related contracts during the cooling-off period, deposits paid in motor vehicle sale contracts, and disputes arising from a contract to buy or sell foreign currency notes made with a licensed money changer were brought within the jurisdiction of the Small Claims Tribunal through the amendment to the Consumer Protection Fair Trading Act of 2008. However, at that time, hire purchase agreements were not included. Therefore, would the Minister kindly explain the previous rationale for restricting the jurisdiction regarding hire purchase agreements and why the same concerns do not arise today? Yet another expansion of jurisdiction is the extension of the limitation period from 1 to 2 years. This provides a bit more leeway for parties to explore different ways to resolve their disputes before bringing the claim before the tribunal. This is especially important in trade relationships where parties may value a continuing working relationship more than a full and open assertion of each other's rights. Secondly, Clause 9 puts into statute an active judge-led approach to small claims tribunal cases. It requires the tribunal to identify the relevant issues and to ensure that relevant evidence is adduced before it. However, I would like to inquire about the rationale for imposing costs. Why is it necessary to impose costs since there is no legal representation. What will be done to ensure that costs will not inject uncertainty into the system? Will the good SMS also ensure costs will not deter legitimate claims being brought by those who may be afraid of getting hit with a cost order? And lastly, in this series of questions, can the public be assured that any cost order will be less than those for claims filed in the state courts? This bill also uses an alternative dispute resolution mechanism, that is mediation, to further enhance its tools for dispute resolution. Clause 7 gives scope for a more heavy reliance on mediation. In conclusion, sir, this bill helps enhance access to justice through the enhancement and clarification of the small claim tribunals' jurisdictions, and therefore I support the bill.